greater knowledge, note the part here, greater knowledge, and relied on by the other will generally be held as a term. Now, we also have, if the statement is made with strength, it's more likely to be regarded as a term unless it's implicitly or explicitly agreed that it cannot be held as such. I've got Schwall and Reed. Again, this is quite an early case, 1913. The claimant purchased a horse from the defendant. The claimant went to see the horse, had told the defendant that he wished to use the horse for stud purposes. Okay, so that's breeding. And obviously, if you are if you have a stud farm, this could be a very, very valuable commodity. Whilst he was examining the horse, the defendant told him that the horse was sound. He stated if there was anything wrong with the horse, he would tell him, and told him there was no need to get a vet to check him out. In reliance of these statements, the claimant purchased the horse, which turned out to have a hereditary eye disease, and therefore could never be used as a stud, because obviously the genes would be passed on. Held, that means the court's decision. The statement relating to the contract was a contractual term. The defendant had assured him he could rely on his word, and the claimant had communicated that purpose for which the horse was to be used. The defendant was thus seen to be in breach of contract. Now, there's a significant difference between the horse and the car. Okay? It would be a different situation. Oh, well, would it be a different situation if you bought the car to the garage and there was a material fault with the car? The garage is going to be a grain wider knowledge. Is that person who has a car going to have that knowledge? No. But if I was to buy a car from a car dealer and I'm being told there's no defect with it, and there is a defect, I mean, bear in mind, stud is being used for a purpose of making money. So obviously it's a material business condition. Similarly, a car would be. And, you know, typically a car dealer may say, well, mate, it's a good runner. What's a good runner mean? Can mean anything. Doesn't mean to say it's sound. Doesn't mean to say it actually works or there's a problem. So irrespective of anything, you know that you would expect that person to be delivering you goods which are sufficient. So we've got the statement of strength, and this is important. And then when we look at representations, a statement that induces a party. That means if I make a statement which is inclined, it's almost like a bit like an invitation to treat, but I'm giving you a statement that's going to induce you into a contract to engage with me to go into this contract, whether it's purchasing or another matter. Statements made in negotiations but do not appear in the final written contract will be held to be a representation, although a collateral contract may have been made. So, with this particular case, the claimant acquired a Douglas BSA motorcycle and a sidecar by exchanging another motorcycle and paying £30. The registration document stated it was a 1942 model, and that is what the defendant stated the year of the motorcycle to be when the claimant came to look at it. The motorcycle was in fact a 1936 model, but had been modified and re-registered by a previous owner. The purchaser went away to think about it, then came back a few days later with a written agreement, which was produced to the effect of the exchange, which ended with the words, "It is understood that when the £30 is paid over, that this transaction is closed." The statement was held as being a representation and not a contractual term. The registration document was not prima facie, but what means it didn't go to the heart of this, of the contractual term, and neither party was an expert. So these were two private people selling things. And there was a lapse of time between the making of the statement and entering the contract, given the opportunity, therefore, to check that statement. Now, there's a really important thing you need to understand in a private contract, because we've talked all about business contracts, and we have a term, and of course, this is something we're going to be looking at as we go forward. But caveat emptor, C-A-V-E-A-T, E-M-P-T-O-R, Latin. Buyer beware. That's what it means. And it's a statement, it's a legal term. And it basically means that two individuals who are selling things privately must go into that deal with their eyes open and not their eyes closed. Because it's unlikely that the courts will find any of them to be a professional on any level. And therefore, it means that if somebody relies on information, that information may well be wrong. And there isn't, the Consumer Rights Act 2015 will not support a private sale. does not support a private sale. The only thing that might support a private sale is if somebody was selling stolen goods, and that becomes a criminal offence. So there's a different matter. And then the person who's buying it can be also guilty of committing a criminal offence too. So one has to be very careful, especially when you imagine buying an Apple laptop for £50. I think it's an unlikely price to pay for an Apple laptop, so the suspicion is that there may be something wrong with that. So the point is, caveat emptor, buyer beware. And more on that in week 7. So terms of the contract. What we have to do is we have to distinguish between terms and what could be perceived as mere representation. So terms incorporated into a contract, as it was with Oscar Chess, was purchasing this vehicle. Terms can be implied by common law and by statute. So what we're saying here, common law and statute. Common law is case law, in the example I'm giving here, can also mean evolving statutory law too, but I'm making it clear to you that there has to be implications by common law, that means case law, evolving case law, and by statute. So that means the outcomes can change. So we look at Oscar Chess and Williams, we might have a case next week which changes the whole course of process, and that therefore no longer becomes the case which leads the position with terms which are incorporated into the contract. So when we looked at the last session, we came across these various terms, and we talked about them last time, so I'm not going to go into them again. So we've got the conditions, we've got the warranties, and we've got the inanimate terms. And they all play part to that contract. But importantly, what we also therefore have is express terms and implied terms of the contract. So, as I said last week, express terms are normally the written terms you find within a contract. Implied terms are the terms which are not in the contract but may be found by a court to be included within that contract. So, express terms. These are agreed between the parties, and it can either be made orally or in writing. Now, the problem that you've got when somebody says, okay, let's go into this contract, and we do it orally, is proving it. Because obviously it's one person's word against another. And we know that on the balance of probabilities, we're looking about a 70% markup in terms of what the courts are going to be looking to find on this burden. And that's going to be very hard. So we might have to then look at how the performance of the parties operated. Terms must be clearly stated. They cannot be ambiguous. Okay? And the main express terms, as I've already said, are found in the body of the contract. You also get riders. So if you go into a business contract, you'll have the terms of it, and then there'll be a rider which will then go at the back of it, which may have a number of other consequential terms to that contract too. So, implied terms. These terms may be implied in a contract in a number of ways. Okay. Now, our starting point is 1, because it's necessary. 2, and that means it's necessary for the contract to operate. And a court may also look at that as being a term when they're seeking an implied term which isn't operable in a contract, but when something hasn't worked, they may then work on the premise, well, actually, that term would need to have been included in order for that contract to work in any event. By custom, how it works within the process of a particular type of contract or a business. Or by statutory terms. Now, this is really important. Statutory terms are changing. I mean, potentially, we know that statutory change may happen because of Brexit, as an example. And therefore, you couldn't operate a contract today which said, the statutory terms within the legal jurisdiction of England and Wales no longer operate because of Brexit. A contract couldn't operate like that. It cannot be above the law. It has to work with the law. So it might mean that during the course of that contract, there may be legal changes. So for instance, we had the Sale of Goods Act 1979, and then in October 2015, we had the Consumer Rights Act 2015, which overtook the Sale of Goods Act 1979, which removed unfair contract terms of 1977 in commercial agreements. So what we're saying here is that if legislation changes, a contract may have to move towards it. It can't be indicative necessarily of old law, okay? Not if it's operating and consistent. So, we come to something now which is quite engaging. is called exclusion clauses. Now, exclusion clauses are terms when somebody says, we're going to, well, I'll give you examples with cases here. I think it's probably the easiest way to go through it. But the idea of putting exclusion clauses is as a rider, if you like, in a contract, which says, if this happens, hey, the contract is no longer operable, or it might mean that we take no responsibility. So, what I put here is an attempt to exclude in whole or in part for either negligence or a breach of contract. That's essentially what we're looking at in an exclusion clause. And I've got two tiers. Now, interestingly, before, and this is, it might come as a surprise, although it probably won't if you've done your reading, but, you know, the Consumer Rights Act 2015 made some serious changes to the way contracts operate, and very timely, although it should have happened many years ago. Sale of Goods Act 1979 was okay, but it had flaws in it. It just didn't operate for the consumer in a very productive way. And therefore, we were very, very reliant on case law. And today we still are. But actually, the Consumer Rights Act 2015 is really good, because there is a clear bar in there under Section 65. A bar on exclusion or restriction of negligence liability. And that is really, really important. You know, if I was to qualify this, it's fair to say that engaging with some companies is still an issue because they don't realise that necessarily that negligence can be excluded with legislation. Forget the case law, with legislation. So, under common law, case law, exclusion must be incorporated, i.e. it must be communicated. All right? In order to exclude a position, you have to communicate it at the contract. And this is very, very important. If you're going to have an exclusion clause, at the point the parties enter into that contract or engage in that contract, they have to understand any parameters which may affect their terms or warranties under that contract or conditions. So, oral assertions can override exclusion clauses, and all of which I will explain in a little bit of detail. So, first of all, let's deal with the fact that the clause must be communicated. So I'm going to look at a case called Ollie and Marlborough Court. All right? Now, this is something which will be familiar pretty much with everybody in this room. In this situation, Ollie paid for a hotel room. I got into the hotel room, put the coat down on the bed, and on there were her valuables, I think jewellery and other bits and pieces. And essentially, what then happened was they went downstairs and came back to the room. When they came back into the room, there'd been a burglary or a robbery, and the furs were stolen, so was the jewellery and other bits and pieces. They went down to the hotel reception and said, look, got a problem. Gone up to left our hotel room. My coat, my furs, jewellery has been stolen. And they said, oh, well, didn't you read the sign on the door? The hotel takes no liability for damage undertaken to goods within the room. And you will have seen this sign pretty much in most places that you've been to. And the court said, it was held that the contract had been made when the room was paid for. And the disclaimer came after this. And as such, it was too late for the hotel to rely on the disclaimer. So you have to effectively communicate it. So if it's not been communicated, and I'll give you a very real case. A few years ago, well, a number of years ago now, I was at a hotel, and I take my wife away for a weekend, and we had a Suzuki Jeep. There was one of those kind of really quite nice Jeeps at the time. Bit of fun, you know. I was in my more youthful days, before I was grey. I was 6 feet taller, you know, that kind of thing. And so there I was. We'd gone off in the Suzuki Jeep and went to this hotel. And it was quite nice because there was various health facilities there. You can tell by my physique that's me all over. And so we went to this hotel, stayed there, and that night, now I have to tell you now that the Suzuki Jeep was a soft top. That means it was canvas top, which means you could unpop a button to get into it. So there was no real, you can lock it and go, geek, geek. Oh, that's great, no one's going to break into that, because they just go, yes we can, and just undo the poppers and go in. So I came out the following morning, and I looked at the side of the car of the door, and somebody had tried with a crowbar, obviously I'm not going to tell you which area of the country I was living in, obviously they lacked intelligence, was to open the door with a crowbar because they couldn't work out how else to get in. And then they tried to get into the glove compartment, which was interesting because it was very small and there was nothing in there. Anyway, the car was damaged. So called the police. But before the police came, I went to the hotel and I said, my car's been broken into. Oh, I see, sir. Yes, well, the interesting thing is I know you've got CCTV around the car park. That's right. Well, so I would like, please, to see the tapes. Oh, it doesn't work. We have that there as a deterrent. So let me get this right. You've got CCTV, but you don't use it. Is that right? Yes. Okay. Anything else you want to tell me? Yes, we have a sign in the car park which says you leave your car at your own risk. To which point I said, oh, no, you don't. Did you engage with me at the time we entered into a contract to tell me, A, that you had induced me into a car park where there was no CCTV? That you had entered into an agreement with me to say that the car would be there at my own risk? Oh, no. Guess whose risks it's at? It's not mine, it's yours. And oh, there's a police officer. Right, so... Interestingly, it was quite good. We had quite a good weekend at their expense. Lawyers do have their perks. All right. So anyway, so the point is that today you wouldn't necessarily need to do that. You could be reliant on Consumer Rights Act 215. But essentially, Ollie and Marlborough Court was a very, very powerful case because it says these terms have to be communicated effectively. So we then have another case to give you an example where we may use a case when it's being communicated. Well, I will do in a second. There's the one after this, but I'll give you another example with a ticket. Now, sometimes, sorry, I've got the slides in a slightly different order. So if I look at this one, Chappleton and Barry is a really important case. Somebody went to the beach, they took a deck chair, which they paid for, and they got a ticket for it, paid the money, and they sat in the deck chair, and after a period of time, it collapsed. And there was a notice on the back of this ticket saying, we do not take responsibility or liability for any injuries that may happen as a result of using our deck chairs, for want of a better way of putting it. And the court said that the council, who owned this store and who were licensed to let out these deck chairs, were responsible. The notice advertising the deck chairs made no mention of the exclusion clause, and it was not reasonable to accept the communication on receipt of the ticket. They needed to be effectively communicated. And again, this is a really important aspect to commercial business. So, an oral exertion, which is what I was going to say to you before. Now, this assertion here is about Curtis, and it's an interesting one, and this is showing you how you have a condition of contract and how this can change by introducing a term which is effectively communicated. So in this case, Curtis took a wedding dress to be cleaned, and they were asked to sign some conditions because obviously the dry cleaners didn't want to be liable for any damage. So they were asked to sign conditions, and when asked what they covered, they were told they excluded liability for damage to beads and sequins. So that meant if there were any sequins or any beads on there and they were damaged, they wouldn't take responsibility. So the clause actually disclaimed liability for any damage to the dress. But when the dress was returned, it was badly stained. And the company could not rely on their exclusion clause because they had misled Curtis to its effect. So essentially what had happened was when they'd gone in there, they said, well, you sign this term here that we don't, because essentially within the laundrette they said, we do not take responsibility for damage to your dress. They said, what damage is that? Well, typically it's beads and sequins. Beads and sequins, okay. Comes back, it's damaged dress. My dress is damaged. Yes, but you signed the form. No, you said that was beads and sequins. You didn't say it would be a stain on the dress. And the court found them liable because this oral exertion, this oral term, had changed the position of the contract. So, with exclusion clauses, to be effective with any form of contract, the exclusion clause must be reasonable and brought to the other person's attention and not hidden in some document where a term or contract would not be expected. So effectively what I'm saying here is that, because it comes back to forming part of consideration, it's about being informed and understanding what the position is. Unusual terms must be brought to the attention of the other party. You cannot, if you've got an unusual term, you can't take it that somebody is going to know about it. You must bring it to the person's attention. Now, when we look at legislation, we did have the Unfair Contract Terms Act, 1977. And these were part of consumer regulations. Now, this is really important. If you have got an old textbook that predates 2000 and I say 16, 17 really, then you may read it and may misunderstand and may then at a later stage rely on something which is going to be inaccurate. In consumer dealings, the Unfair Contract Terms Act 1977 does not apply. It still does in businesses, but not in consumer dealings, because the Consumer Rights Act 2015 has superseded this and repealed, means extinguished that legislation for consumers. So this act governs the use of exclusion clauses in contracts. So if you're in a business, you may have you may rely on that particular piece of legislation. It also prohibits the exclusion of liability, death, or personal injury, and any other exclusion clause is subject to a test under the Act's assessment of what is reasonable. And think of the reasonable man test that we talked about before. So when we look at the consumer versus trader, what you can exclude and what you can't exclude, etc. Consumer contract, liability for death and personal injury and negligence comes under the Consumer Rights Act. Okay? It's under the consumer regulations. So it's the Consumer Rights Act 2015. Sorry, that doesn't kind of say that, but that's what it is. So please make a note of that. It is the Consumer Rights Act 2015. The non-consumer contracts, non-consumer contracts look at the previous legislation with regards to this, but importantly, there are implied terms which may still be in the Sale of Goods Act 1979, which still are effective for business-to-business contracts, but not business to consumer. The point you have to take on board this morning is that anything going further forward is the Consumer Rights Act 2015 for the consumer. Unfair Contract Terms Act 1977, Sale of Goods Act 1979 are for business to business only. And if you read a textbook which predates 2016, the information you'll be presenting will be inaccurate, okay? And I still say this because I know it's only a few years ago, but it's still easy to make that mistake. All other clauses must be reasonable or statute will disallow. So, we have our reasonable test, which is what we call the bargaining position, inducement and knowledge and compliance with the condition. So, again, these are the factors that the courts look at in terms of was it reasonable. And this is almost, when I look at the comparability of when we looked at tort law and we talked about what the reasonable man test is, this isn't that far removed. The fact is, bargaining position, how did you bring the parties into this position? And then as a part of that bargaining, what was in the minds of the parties at the time they entered into the contract? But more importantly, what was the inducement? What was the knowledge known by each party? And have there been compliances with each of the conditions within that contract? A statute will approach it in this way. The Consumer Rights Act 2015 does this very visibly. Now look, at this point, I'm just going to take you through. Now, I've put together a document this week, which I think I got overexcited. It has somewhere in the region of 26 pages, so I was very excited. I thought you were very keen students, so I felt I wanted to look after you accordingly. But joking aside, this document here is going to be critical in your pathway from week 6 onwards. Okay, after the class test, although obviously, of course, anything in here may be part of the class test. I can't give you that exclusion. But what I am going to say is that everything in here has a pertinence and an importance. And the design of this is to marry against any textbook that you're reading, and certainly the ones that I've introduced you to. But importantly, they also reflect what's going on within this lecture. So, and I think in this particular session this week, what I did do was I put in here, in some very clear terms, the Consumer Rights Act 2015. And so you could actually see how that legislation operated. 2 weeks ago, I said to you, or it might have been last week, I forget which, but it was either last week or the week before, I said to you to take a copy of the front page of the Consumer Rights Act 2015, just that index, okay? I've put it up on Surrey Learn, so you've got it there. But you need to have that, and you need to understand that and to work your way through things as we go forward. Obviously, I'm not going to test you on specific legislation in the class test. I can tell you that now. When I say that, I'm not talking about legislation, the names or things like that. I'm talking about the context. I wouldn't say, what's Section 6 of the Consumer Rights Act 2015? How does that operate? I'm not going to do that. Okay. So, our contract. Now, when we look at exclusion clauses, and then we come to vitiating factors, misrepresentation. And this is a really important area of contract law. So on one level, we can look at an exception to a rule by including a statement which we may want to be deemed as part of it. But on the other hand, we may have a misrepresentation, something which goes to the heart of the contract, which induces the parties into the contract. And this we need to go through into a little bit of depth. So, our starting point. The misrepresentation legislation. There is legislation, and we have the Misrepresentation Act 1967, and we also, it makes rise now to the Consumer Rights Act 215, but we have the Consumer Rights Act 215 also, which addresses things. This is important because in a consumer deal, we need, or a consumer contract, we need to be very clear that no misrepresentation has happened or induced the party into entering into a contract for reasons which obviously that contract cannot perform with. So we have the Consumer Rights Act, which again you can look at. But what are our vitiating factors? Well, they include effectively 3 types of misrepresentation. And these 3 types are fraudulent, negligent, and innocent. Now, fraudulent misrepresentation is when a party makes a false statement of fact that they do not believe is true. For example, come and buy this car. It's as a car dealer selling you a car, it is a car which is a 2017 XYZ, and it's only done 50,000 miles on its clock. But actually, I know as a car dealer, yes, the year is right, but the mileage is incorrect because it has probably been clocked. Looking at the wear and tear of the car, it is certainly driven more miles, but I am selling it to you as this. This would be seen as fraudulent misrepresentation. Knowing from the outset the information that you're inducing a party into a contract is incorrect in a serious material way may give rise to a fraudulent misrepresentation. Negligent misrepresentation is probably the position we tend to find most areas where misrepresentation may arise. And this is where a false statement of fact, because you need to understand this, is a factual statement which you rely upon, which is incorrect, made by one of the parties. A false statement of fact made by a person who believes that statement to be true but has no reasonable grounds for that belief is a negligent misrepresentation. Example, you go into XYZ computer store. Oh, can I help you, sir? Yeah, I'd like a computer that does X. Oh, well, the new Apple, I know it's £3,000, but you want to use Word? Well, I think this will be the best one for you. The fact that, of course, all the other computers can do exactly the same thing, but that person may be considered or minded that actually may be what that actually does or is. But it would be potentially a situation of a negligent misrepresentation because obviously other computers could do a similar job. So an innocent misrepresentation is a false statement of fact made by a person who has an honest and reasonable belief that it's true. Okay? Now, in an innocent misrepresentation, the courts are likely to potentially find that they may view the contract very differently from the position of a negligent and a fraudulent misrepresentation. So, a misrepresentation, a false statement of fact. It induces that party into a contract. It makes the contract voidable, okay? Doesn't mean void, i.e. comes to an end, that's it. It can either end or it can be continued. The parties misled could ask the court to rescind the contract, i.e. put the parties back into the position they would have been before they entered into the contract. Damages are generally not awarded if misrepresentation was innocently made. And this is a very important point. However, under the Misrepresentation Act 1967, the court may award this in lieu of an order of rescission, i.e. they may order damages instead of rescinding that contract. Now, importantly, the Consumer Rights Act 2015 deals with this head on. And it requires notice and terms in a contract to be fair. And this is really important because actually that's a broad paintbrush here, because if you enter into a contract where misrepresentation may arise, under the Consumer Rights Act, which is a statutory piece of legislation, that means if those terms are deemed to be unfair, the court simply has to rely on the legislation to exercise its position over the contract. And the option of rescission may be lost if the contract is affirmed, i.e. both parties agree and understand that, and they continue through that contract. Affirmation may also be effective through the lapse of time, i.e. knowing that there's been a misrepresentation, but failing to bring it back to the other party's notice or give attention to them. So, a false statement of fact induces the party into that contract. Importantly, a statement is not silence. So if somebody is silenced, remember what we said last week, you cannot enter into a contract, there can't be any consideration for offer and acceptance for silence. And equally the same thing may be applied to a misrepresentation. So a statement is not about silence. It's a fact, law, intention, or opinion. Inducement must be relied on and be material to that contract. It must have engaged those parties and it must be material to the contract. Yes?
If, for example, in the case of a clause avoiding liability and omission in that case would mean that liability could be
if omission by the party who had misled or by a party who had not misled.
Okay, so if a statement isn't silenced, does that mean there's no cover for omission of material?
Okay, so if a party remains silent and they engage, then if there was a material misrepresentation that could be made on silence, well, entering into a contract, you would know what those contracts requirements are because they would be communicated. So, for instance, if you purchased a vehicle and it was and again we'll just use it as a car which had done 50,000 miles but it had done 70,000 miles, it had a card on the clock showing that information.
So therefore it's not silent.
It's not silent because it's been communicated in other ways. Yeah. So, Misrepresentation Act 1967. Under the Misrepresentation Act, negligent misrepresentations will be treated as fraudulent misrepresentations. Okay? However, an innocent party does not need to prove a fraudulent misrepresentation. Now, the courts, obviously, there are different outcomes from this. You know, a fraudulent misrepresentation, and let's deal with it in the sense of not a negligent, but a fraudulent, where a party has relied on information which has induced you into a contract, knowing that that contract was wrong, could into a criminal proceeding. All right? So there are some very serious overtones for this. When we look at the remedies, what are the remedies? Well, reliance. And that means we put the innocent party back into the position they would have been had that representation not been made. Now, in a lot of cases, that might be a refund if it was a purchase. It might be a material change in obligations of a party if there was a service that was required. And the court will look to rescind all material misrepresentations within that contract. And that contract could be voidable. That means it can either end or it may be continued, depending on what is decided. And when we look at damages, and remember, I will never ask you what the sum of damages would ever be, and you must hold on to that. That will become very important after week 6. But damages in the tort of deceit and the tort of negligence are reliant on the tortiousness of reliance, so i.e. what that party relied upon. And I've got something coming up in a minute that will give some more clarity on this. And we'll look at the remoteness of damages. Damages would be awarded to cover the losses which flowed directly from the statement which was made, that was untrue, and whether or not those losses were foreseeable. Okay? So you might have losses which come around. So, for instance, if you purchase something and you were told it did a particular function but it didn't, and in your and in the paper that I'm going, your mock exam paper, which I'll be putting online on week 7, I've got an example of similar kind of position that we're talking about now, which we will be focusing on, which you will be seeing me all on a one-to-one with the view of that script of what you have written as an exam answer. And that revolves around a similar situation like this. And when you are looking at damages, if damages which could be taken into account could be transportation backwards or to, or maybe use of another particular material object because this one has failed. These are things that they're not things which you can just dream up and think, oh, this must be worth a couple of £100 just because I feel hard done by. They have to be materially evidenced. And we'll be looking at this in a lot more depth. We've got a key case on this, Hadley and Baxendale, which deals with the remoteness of damages. Okay? And again, we'll be looking at that at week 7 onwards. So, I've got a question for you. And I want you just to have a quick chat amongst yourselves. A breach of a blank will not enable a breach of contract claim, but may amount to a misrepresentation that makes the contract voidable. So, with the person who's sitting next to you, and of course if you've not introduced yourselves, which you should have done already by now, I want you to tell me what you think the blank is, please. So have a quick look at the question, and then tell me what you think the blank is. Now, the clue on this one is really you're in a contract, you've got a breach of something, but it has an outcome. And this outcome will not enable a breach of a contract claim, but may amount as a misrepresentation that makes the contract voidable. So it might make that voidable. And there's only kind of 3 things it might be. So, who would like to give me a suggestion? Anyone got a suggestion that they think you might know the answer to this one? Yes? A warranty, okay. That I'll hold on to that and I'll come back to that in a second. Okay, a warranty. Any other suggestions? A term. Okay, so it might be a term. What kind of term might we be looking at? Okay, that's all right, that's all right. Thank you. Any others? We've got 2 others it might be.
Duty.
Duty?
Yeah.
No, not duty. An express term? Well, it could be an express term, but if it was an express term that went right to the heart of the contract, what would it be? It begins with C and finishes in N. Anyone? Condition? Yeah, so it might be a condition. Okay, well for this one, it's quite straightforward. It's a representation. Okay, it can't be a condition, because a condition goes right to the heart of the contract, and that would change the outcome. All right? So it's a representation. So if it's a representation, it's not a term to the contract, and we did say term to the contract. A term would be a condition, because it's material, and it requires either party to execute something in a way to make that contract operate. And it's not a term, so it will not allow an injured party to claim breach of contract, but it may lead to damages, potentially. Okay? So, with that in mind, I've got a question for you. So listen very carefully. And I want you to think outside the box a little bit on this, but here is a very real sort of situation. Last week, Tim was induced to buy 500 shares at 60p each from Michael. At the point that the financial transaction took place between Tim and Michael, the shares were actually only worth 45 pence a share. Tim became aware only after the purchase of the true value of the shares, and rather than rescinding the contract on the knowledge of the fraud, decided to sell them all for 20 to 35 pence a share. Now, you've got to advise him on his legal position. What is the position for Tim? What is he going to claim? Now remember, we are potentially looking at what? What are we looking at? Begins with M, finishes in N. Misrepresentation. Right, okay. So we're looking at misrepresentation. So there are three areas of misrepresentation. We've got fraudulent, negligent, innocent, and you need to think about those when you're applying those to this particular question. So, in your pairs, have a look at the question. I'll give you a couple of minutes to look at it, and then we'll look at what your answers are. Okay? Wakey, wakey. Right, you want to count? You all right there? You all right?
Yeah.
Good, good. Well, wake up then. Don't.
Asleep.
All right, okay. Do you want to come in and join in and try and work out the answer then, please? Yeah. Okay, all right then. Now we have our situation here which really deals with misrepresentation. I'd just like a show of hands rather than perhaps giving a more in-depth answer at this point to start with. How many of you think this is innocent misrepresentation? Oh, I see we've got a firm hand which is going to come down here, okay. How many of you think this is fraudulent misrepresentation? Oh, well, we've got quite a number of you there. How many of you think it could be negligent misrepresentation? Very few. That's very lenient people here. So the majority of you are very punitive, I can tell. Okay, well, we have quite an interesting situation. Let's have a look at it. Now, we know there are three types of misrepresentation. We have fraudulent, so we're talking about a statement of fact that the other party relied on to enter into a contract. But this fact was misrepresentation. And it could either be fraudulently given, i.e. the person knew that information to be incorrect at the time when they sold the shares, or B, they knew it to be, to the best of their ability, they thought it was right, but they thought it could also be wrong and the information wasn't necessarily quite correct, or innocently, they knew at all times. Right, I'm going to put the bar right down here now. In business, we cannot have innocent misrepresentation. Why? Because when we look at the bar, we know that bar to any forms of misrepresentation, we've got the Consumer Rights Act 215, which gives us some support and underpins this, that everything must be, you must act in a fair and be using due diligence, and therefore that standard is much higher. So it will either be negligent or fraudulent. We can remove innocent. Innocent misrepresentation might happen between two private parties, but not between a business, because the business would have known, they should have known, or they could have known. And if they didn't, then they were negligent. Now, in this situation, Tim was induced to buy 500 shares. Now, is there anything in here which mitigating, looking at Tim, could affect Tim's position? Anyone got any ideas of what might affect Tim's position here? Yes? So he sold them, and what should he have done?
Perhaps held on to them and negotiated the original value.
Or gone back to the person that was there. Okay, good. Right, now, here are a couple of things. Now, what we'd need to know are the facts of this particular case. So, for instance, Tim was induced to buy 500 shares. So induced means that he was the information he was supported or given by Michael was enough for him to part money, enter into a legal binding contract to buy shares. However, when I say think out slightly outside the box, one of the issues that might have happened is that Michael could have been using a terminal and that the shares that were priced that he was given at that time were correct under the processes by which he was using. He may not have known there was a dip or a devaluation of shares from the information that was provided to him. Now, there can be cases where this can happen. And it could be because there was a timeout or some other individual approach. Of course, there is a remedy for that, but that wouldn't be fraudulent misrepresentation, that would be negligent misrepresentation. Fraudulent misrepresentation means that Michael made out from the outset, knowing that those share prices he was going to capitalise massively on them. Now that isn't the situation, and as you know that there's, or may know, in terms of trading, when you enter into any trade negotiations, the information which is often given to you is correct at the time of purchase. Thereafter, it may change. Yes?
So you said in business there's no misrepresentation, but how do we know that that they're actually part of the business?
Oh, no. Okay, so what I said was in business there may be no innocent misrepresentation, so it would either be negligent or fraudulent.
We don't really know the relationship between Tim and Michael.
Agreed. So
It could just be friends.
It could be friends. Although an argument you could have is that these were two friends selling shares, they may have both gone into their eyes open, caveat emptor may apply, and innocent misrepresentation may happen. But on the other hand, there still could be fraud going on between two people who are not businesses, okay? But it is a caveat emptor. But let's take this from the position, it's a well-made point, but let's take it from the position that this is a business and that he has sold the shares on to him. At this point, I would assume in this position here that this is a matter of a business being sold from one party to another rather than a private one, yes. So, but the point you're making to back up is completely accurate and correct. So, when we look at this now, the position becomes, if it can genuinely show that Michael sold shares knowing that the share price was incorrect, then fraudulent misrepresentation may have taken place. And if that were to be the case, then possibility of criminal liability may also arise from this too. If it was a situation where it was negligent, then that position is slightly different. And he may go to court and seek, and this is where we'll now look at the latter part of this question, he may seek some form of rescission. So remember, that contract could be voidable. But here is the problem. Tim sought to sell his shares rather than bring it to the attention of the other party. So the court may argue he didn't fully mitigate his circumstances. And therefore, whilst there was a transactional difference on the share, any damages, if they are awarded by the court, and there's no guarantee that they would be, because here's the thing. Tim accepts the share value and then sells them on. And it would be a very fine line for the court to drive, because actually what Tim should have done is not sold the shares, gone back to Michael, and failure to get the difference in the share value of monies, then seek to take that matter to court, thus making the contract void and be put back into the position he would have been, or voidable, keep the shares but take the difference in money. But the position that Tim has taken has changed because he has confirmed the acceptance of that. And mitigation will not support him through this process. So there are different outcomes here. But what I think I'm trying, this question is really designed to do more than anything else, is really to do two things. One is focus on the fact that fraudulent misrepresentation is a very high bar, and it's more likely to be negligent. Secondly, the actions that the other party where the misrepresentation has happened to become incredibly critical to how that contract, because there's an acceptance by performance of the diminution of that value of each share. Okay. Any questions on that? Go on.
You mentioned earlier that negligent misrepresentation would be treated as fraudulent under the Misrepresentation Act.
Mm-hmm.
Does that mean there wouldn't be a significant difference in damages awarded, no matter what was?
No, the damages, if it was, I mean, the courts would have to differentiate. Whilst under the Misrepresentation Act, if it was applied, it would be seen as a fraudulent misrepresentation. It would be down to the courts as to how they then approach that. If it was criminal, they'd pass it to the CPS. If it wasn't, they would maintain it through the court. But essentially, you would be looking at damages as a result of that. But unfortunately, in this case, it's unlikely to happen because he sold the shares on.
Yes.
Okay. Okay, so misrepresentation. It's really important you understand the differences between all three. Fraudulent is a very high bar and very rarely successful. Negligent is probably our key area. Innocent misrepresentation may apply, but not in a business relationship. Because where one party is a business, they cannot rely on an innocent misrepresentation. Okay? Take Oscar Chesson Williams as a clear example of that. So, duress. Now, duress is a tort, and we do see a duress coming into contracts. I talked about this very briefly last week, and actually in the news, in the week that's been going on, we've had a case, a criminal case. That case. But that could have significant outcomes in a civil trial too. But when we look at duress, it's about applying duress on a person. And we tend to see this in some contracts. And last week I gave an example. You're going to buy a house, and you may have one party that puts pressure on another to put misinformation on the appropriate forms in order to secure a contractual agreement. So duress may consist of physical duress, i.e. violence or threat of some violence or an activity. And if the courts see this as being applied in a contract, that somebody applied duress on another party, that contract may be, and you must understand this word may is so significant, may be voidable. Now, the House of Lords extended the concept of duress beyond physical violence to include unacceptable economic pressure, where the other party had no option other than to proceed with the contract because of their circumstances. Again, that may cause the contract to be voidable. Undue influence. Well, as opposed to a physical or economic threat, undue influence involves the exploitation of another party's vulnerabilities. This can include exploitation of a fiduciary relationship. That might mean a fiduciary relationship. If you are a director of a company, you enter into a fiduciary relationship with other directors, and it might be pressures that have been applied to this. Relationships such as doctors and patient, parent and child, solicitor and client and so on, generally have the presumption of undue influence if the contract cannot be explained by their relationship, because one party relies on the other for the correct information, and that is applied through that. So there's a presumption that if there is something which has gone awry, that it may well be down to one of the parties who had the wider knowledge. And undue influence is something, if you were law students and I was talking to you through tort, this is a really large area of tort law. But in contract, I think for you, it's important you understand that if one party applies pressure into entering into a contractual relationship, that may make the contract voidable. All right? It's not about misrepresentation. It's about duress. So what happens? We've got discharge, we've got breach, and contractual remedy. So this is how we're coming to our sort of conclusion when we discharge our contract. So when we talked about discharge last time, we talked by agreement. That means that both parties have performed and executed everything that they needed to do within that contract. It has now come to a formal end. The contract is discharged. Performance must be exact and complete. It must be executed in the way that that contract was set out between the terms of all the parties. Frustration means the contract has come to an end because one of the parties cannot fulfill their obligations because of an unforeseen event. This can make the contract voidable. Doesn't necessarily mean to say it's going to be void. Then there may be a breach of a condition where one party breaches the contract by an action which categorically goes against a condition of that contract. And that could be either a straightforward breach or an anticipatory breach, depending. So when we look at what the remedies of that are, well, we have damages, which is going to be a financial sum, an action for the price of the damage which has engaged in. Quantum merit is the, I call it quantum for short, but quantum is the amount that the courts will award in that situation. There may be equitable remedies too, which may be non-financial. It may mean specific performance. That means a party must continue its obligations to continue and perform under that contract. There could be an injunction, that's a prohibitor to stop somebody doing something under that contract. And then there may be rescission of the contract, which means to put the parties back to the point they would have been prior to either entering into it or at the time where that breach occurred. Damages, well, there's a doctrine of restitution, which looks at the aim of the damages and what compensation may arise from it. It is not a punishment. Now, I'm just going to bring you into kind of a clear term here. When we look at courts, and you often hear on the television, even with criminal courts, punishment is the wrong word. We look at restitution. We looking at trying to change actions, looking at people's when somebody has done something, whether it's criminal or civil. It's not about punishing. It's trying to restore a natural justice to a position. Rehabilitation is the correct word in criminal law. It's not punitive. It's about rehabilitating an individual so they can go back into society again and not recommence in the actions that they were doing before. Sadly, the reality of that is when most people go into prison, which is typically often within the male category rather than the female category, and often between the ages of somewhere between 16 going up to about 28, which is a very high populace. Individuals who go in there as a first-time offender often learn and come out an absolutely clear, wide criminal with a wider understanding of criminality. So that's a separate question. That's an issue of law and justice. But when we're looking at civil law, it's a slightly different situation. And what we're looking at here is we're looking at a form of compensation to compensate the party, not to make it an advantage to the party. And that's really important. The remoteness of damage is the loss of bargain. It's the loss of how that damage is taken, how it has an impact on the contract. We'll look at that in more detail when we look at Hadley and Baxendale, which is the key case on this, which talks about the losses that are accumulated through this. We look at the measure of damages too. What was the actual loss that was suffered? Was there a non-financial loss? Was there mitigation between the parties that needs to be taken into consideration? And were there penalty clauses? And in business, penalty clauses can be included within a contract. So if you ended up, so for instance, a building contract, and it's very hard to get a builder to agree penalty clauses, but if I was building an industrial site, maybe a new hospital, I would be putting penalty clauses in my contract, and it would state that Section 1 of the hospital, for example, needs to be completed by this date. Any time that has not been completed after that date, you will be fined X amount of money, and that will go back into the build. Now, effectively, if you had a poor builders who were doing it and they failed on all counts, you could have your building constructed free of charge, in theory. And that has happened, okay? But the point of making penalty clauses are clauses that you invoke into a contract, invoking on the other party if they do not complete something by a set time or an action by a particular approach, there may be consequences which may arise from that. And often they're pecuniary, which is money. So we have specific performance, which I think we've kind of looked at in some detail today. It's an equitable remedy. It's seeking to enforce a contract to continue, but there may be exceptions within that contract of parts of it that may have to be continued. Be down to the court to agree upon. We have an injunction, which is again an equitable remedy, which is a prohibitor. It prevents a contract from doing a particular or an action of a party if there's been a breach. And then we have rescission, which is the equitable remedy, which treats the contract at an end, but generally tends to put the parties back. Right, ladies and gentlemen, we're going to take a break now. It's now 22,